Can I come to Barrister Rashna Imam, Advocate Supreme Court, and also Managing Partner of Akhtar Imam and Associates?
Assalamu alaikum. Contrary to what Mr. Bijoy said, I may take a little more than 5 minutes since lawyers like to talk. Honorable State Minister of Finance, President DCCI, distinguished panelists, ladies and gentlemen, Assalamu alaikum. Legal practitioners like myself and the business community alike have long felt the inadequacies of the Companies Act, be it in simplifying business procedures as highlighted in the keynote presentation, be it in simplifying exit procedures or insolvency mechanisms, or improving accountability of directors, improving accountability of auditors, speedy dispute resolution mechanisms, and the list can go on. But what I'm trying to say is that, as has been emphasized by the panelists before me, a robust company law regime is essential to creating an enabling business environment in Bangladesh, and it's essential to foster investor confidence. So to do that, a draft bill has been doing the rounds for quite some time. While the draft bill, in my legal opinion, does address some of the concerns raised, but it also does raise some additional concerns which I'd like to discuss today. I realize that there is a time constraint, so I had to prioritize myself, and I'll probably build on some of the points raised in the keynote presentation. The first point, this is, and I speak for the legal fraternity, the judiciary as well as the bar, is the colossal backlog of cases in the High Court division. In the entire High Court, there is only one bench that deals with company matters. And even that bench is not devoted to just company matters. It has the power to deal with a host of other matters. This creates a problem. And I've heard it time and again from my business clients that disposal of company disputes in the High Court has no connection with the speed with which business is being done today. There has to be a connection. And this problem can be solved through legislation in a number of ways. Some of the solutions that I've discussed with DCCI is to have 2 company benches to start with, or alternatively what India has done. There is a specialized tribunal that has effectively taken over a lot of the workload from the High Court. In India, that's the National Company Law Tribunal. We can have something like that. And then building on what one of the distinguished panelists said, the RJC has to be empowered. This could effectively relieve the court's burden, at least the administrative burden of the court to a great extent. And other than that, of course, there is alternative dispute resolution mechanisms. You don't have to go to court every single time. So the law, the existing Companies Act does contain an arbitration clause, but that is hardly ever used. So we need to start encouraging use of alternative dispute resolution mechanisms. I believe FBCCI has an arbitration panel. So businesses could be encouraged to go to that panel first and try and settle their disputes there before increasing or adding on to the burden of the courts. So moving on from the first high-level concern, the second one I have, which distinguished panelists just before me highlighted, was mergers and acquisitions. Even though I realize that Bangladesh is at a nascent stage so far as M&A is concerned, unlike India where it's booming, but having said that, last year itself saw 2 big-scale mergers and acquisitions, Robi Airtel and even the intra-group merger of the Summit companies. Given that, are we ready to deal with an inflow of M&A that's bound to come up in the years to follow? We're clearly not ready. The existing Companies Act has only 2 sections that deal with M&A. No guidelines. I've had the privilege to talk to the judge, Honorable Judge of the High Court Division, who authored these 2 judgments, the Robi Airtel and the Summit. And he said that he faced significant challenge because there's a legislative vacuum. There are no clear guidelines as to what is the benchmark against which a merger should be adjudicated and sanctioned. How do you decide sufficiency of mode of valuation? And to mention a few other things, independent audit. There was extensive discussion in these judgments that should there be an independent audit. So we need clear regulatory guidelines. I believe the bill, to a significant extent, fleshes out mergers and acquisitions. but there has to be BSEC guidelines, there has to be corresponding foreign exchange guidelines for cross-border mergers, and a regulatory framework has to be put in place. To move on quickly to my third and a major concern, across the bill, I have seen provisions that could lead to over-regulation of the private sector. This is of major concern to the business community, because over-regulation might end up choking and paralyzing the private sector. And that is never a good thing for any economy. By over-regulation, just to cite a few examples, in the minority protection provisions in the bill, there is a provision that says the government can apply to the court for relief if the government feels that that the company is being run in a manner that's against public interest. Now, as a lawyer, I'm very scared of the term public interest, because public interest is too vague a term, too broad a term, and anyone can just about do anything and say it's in public interest. So whether this level of regulatory scrutiny is undue or unwarranted, we need to think about that. And the other thing that I noticed is what Mr. Nohe Latif Khan highlighted in his presentation was Anti-Corruption Commission has been empowered to investigate affairs of the company. Just to say that the existing Companies Act had a very strong investigative regime under it, but that was never enforced. So if we keep that and try to enforce that, that will be sufficient. Do we need to strengthen this further, empower the ACC, and that too, ACC is dependent on the government to initiate investigation? And if we are to learn from the Indian experience, because this has been copied from the Indian Companies Act, where the Serious Fraud Investigation Office investigates, and this investigation has to be assigned to them by the Indian government. India has not had a good experience with this provision. So are we likely to have a similar experience? If so, then we should do away with it. And lastly, I believe I am taking up a lot of time. Minority protection introduces US-style class action suits. While we enjoy seeing this in American television shows, is Bangladesh actually ready for that? Or is it going to create more frivolous litigation and increase the burden of the courts? And just to wrap up, ladies and gentlemen, accountability of directors and auditors, the bill codifies directors' duties, which is a great move, as directors need to know what is expected from them. Accountability of auditors have been improved by imposing hefty penalties, which is also a good move. So in all, my final comment would be, we should be very careful if we are to base our Companies Act entirely upon a foreign act. We have to customize it to suit the needs of Bangladesh, and we have to remove what is bad, benefiting from the Indian experience. Not all in the Indian Act is good. They are suffering because of a number of provisions, and we have to cherry pick what's best for Bangladesh. I sincerely hope that the concerns raised in this discussion is taken into account and in finalizing the draft, and some of the solutions assist in finalizing the draft. Thank you for your patience.
Thank you, Barrister Rashna. I think the 2 points that I've captured here is the Robust Companies Act, the specialized tribunal, I think is very important, and the second bench for faster movement of cases.